SJC-13225, Commonwealth versus Lazaro, Miranda.
Attorney Kelly, whenever you're ready, take your time.
I was actually running the train. I don't know how much I enjoyed that. Appreciate you indulging me. Good morning, Your Honors. If it please the court, my name is Brian Kelly. I'm representing the defendant appellant Lazaro Miranda.
Mr. Kelly, what do you do with all the cases that say that if there's no contact, there's no sudden combat? Thinking specifically of Curtis, I'm looking at Broom, but many other cases as well.
I would suggest to the court, Your Honor, that, in fact, there's the case cited by the Commonwealth in their brief was Lugo, and also Curtis and Ruiz. But in this particular case, I wholeheartedly agree. There was no contact. He did not get hit with, if we are to believe, of course, Your Honor, and taken it as correct, that he would be swung at with a machete. He did not get hit with a machete. I would call the court's attention to the language in that Lugo case, which says generally a victim must either initiate or strike the first blow. And I would suggest to the court that in this particular case, where some of the other cases like Ruiz and Curtis, which were cited by the Commonwealth in its opposition, that those cases or someone hit somebody, somebody slapped somebody, someone jumped on someone's back. This is a machete. I would suggest to the court that if someone swings a machete at you and barely misses you, it still would raise the same amount of
Was it sheathed
compact.
when she swung it? Was it in its covering?
Your Honor, there is evidence that it was still in the. I'm only going with
Bedroom right behind the door or something?
Yeah, I mean, they were.
Where was she killed?
She was initially laying down in her bed after coming home from work, and I guess some time after work. Her eyes closed. The discussion started. What's going on? Supposedly her braids.
Killed in her bed?
I'm sorry?
She was killed?
No, Your Honor. As I understand the facts, that there was an altercation. I think she did get out of the bed. She was actually killed in the stairway of the apartment building.
She was stabbed 33 times in the stairway.
Yes, exactly, Your Honor.
It's a bit more than you need for self-defense.
Oh, Your Honor, we're not.
Not self-defense, but sudden provocation. Still a bit much.
Well, in the particular case there, I would suggest that it's he testified or spoke to the expert Ebert, saying he just snapped. Yeah.
Can I ask just before you leave it? So the facts are, I understand that her machete is found in a sheath, but we're looking at the facts in the light most favorable to your client, right? He testifies that she swung the machete at him.
She actually says and it's, again, this is also unclear, Your Honor.
Right.
He says she moved for or swung, and it was never differentiated. No one, I don't believe anybody ever asked that. I would suggest that a move for is not as threatening as a swinging of a machete, but again, those are the facts that we're told.
Well, it's a little better. You get a little bit better with Dr. Ebert, I think.
Right.
Yes.
Dr. Ebert is a little better for your client.
Oh, yeah, and again, but this is the one that obviously we don't have him actually, we have his report, but we don't have his.
But his report says, I'm just trying to, again, I understand there's no contact.
Right.
But I am troubled a little bit. If someone's swinging a machete at me, and they're right in front of me, I don't know if that's enough for sudden combat, but is there a separation, though, because she's killed down the stairs? Do we know where?
We would contend, Your Honor, that it's not a matter of just a knee-jerk reaction. You swing at me, I swung at you, and oops. I mean, obviously, she was struck 30-some-odd times.
Right. No, that's clearly excessive.
So clearly, that's not the situation. But in that particular case, I think they chased each other around, he chased her or whatever it was. But in addition to, Your Honor, saying if someone swings a machete at you, there was evidence that he told at least Ebert and I believe Detective Keeler that she had done that before and actually had previously struck him.
Right.
Which I would say puts a little extra emphasis on the provocation, if you will. If somebody hit me.
If Justice Kafka is right, and that swinging the machete is different in kind,
Right.
will this be the first case where we have ever said you can have sudden combat without contact?
The only thing I could not.
Because I
Again-
couldn't find one.
Well,
where there
again,
was
the
no
only thing
contact.
I have to go on, Your Honor, to support that contention was, again, the Lugo case, which just said generally. It doesn't say exclusively, always. It just said generally a victim must initiate or strike the first blow.
I don't know if you looked at Commonwealth versus Brown.
Yes, Your Honor.
So Commonwealth versus Brown is where the victim choked the defendant with a shirt, and that was insufficient for sudden combat, where the defendant stabbed the victim 6 less times than the stabbing here. 27 times in that case, and that wasn't enough for sudden combat, the choking.
Yeah, I mean, I agree with Your Honor with this, as far as this is. This could possibly be this. The only thing I have to go on in response to that would be the fact that there's just a, generally it does not say exclusively, and I would say
One
that.
other thing to go on, and it goes to another issue you have about the record.
Yes.
And that's that there doesn't seem to be, from what I can tell, any request for a limiting instruction on either side as to what the defendant told doctors in this case. So that evidently came in for its truth, and we don't have all that testimony.
No, Your Honor, we have nothing from Dr. Ebert. We have actually nothing as far as the jury charge.
So you've got an issue that the stipulation is not enough.
Well, it's kind of a conditional argument, Your Honor. And the reason I did is, in fact, this is the only time that I've been in front of any appellate court where I can actually say what the attorney in the lower court did, because I actually jumped into this case and was involved in the reconstruction of this with Judge Locke.
He was very complimentary of counsel.
He was phenomenal, and I have to say, in total deference to everyone, attorney for the Commonwealth, Halisaxis, who unfortunately is not with us, did a phenomenal job. Everyone did a great job as far as putting that thing together as best they could. And the only reason that I actually raised the issue, and I actually raised it after we had the stipulation ready to go, was it was still on the table. I had put out a motion for new trial back in 2012, and it never was addressed. The judge just said, reconstruct it, and we did. I mean, if the judge says jump, I say how high. So he says, he said we're going to reconstruct it. We reconstructed it, and I just wanted to make sure we had everything done. The judge was nice enough to allow us to meet with all counsel at the same time. That way we could say, what do you say? What do you say? What do you say? Which we can't do on a stand. And he allowed us to do that, and we all agreed to as much as we could agree. And the point was that and I still think that it's because we're dealing with jury charges and jury instructions and things like that, that can get very difficult to reconstruct. And Judge Locke asked me specifically, give me a nutshell. And I basically said the nutshell is that they asked, these instructions were requested. They were either denied or ignored, and it was an objection to it. Counsel for the Commonwealth said, yes, that's true. And I said, okay, if that's the case, then we're fine. But I still would like something on the record, because I did file a motion for a new trial. And by the way, I do concede the fact that it was not the Commonwealth's fault. There was an issue that I had put in there because it was lost by the clerk in the court. And that is not true. It was not the defendant's fault, but it certainly was not the Commonwealth's fault. I concede that point. If I may, Your Honors, I would like to address the second issue as far as the request for the instruction on mental impairment and intoxication. And I asked the Commonwealth, I felt, put together an incredibly fair brief in response to my brief. But in doing so, they did not seem to pick up too much on the portion of my argument that was, I had put it together on a couple of pages there, citing a lot of language from the McDermott case. And I call this to the court's attention in case I was not eloquent enough to have emphasized that since we don't know what was actually given, we can stipulate that it was given according to the model jury rules, but we don't know. And all we have to do is, in the record appendix, if you once you do take a look at it, you'll see where they went to the motions for jury instructions. You'll see check marks all along the way and little notes on the side. And the only thing we have to go on is what got checked off, what didn't get checked off, and that was the only thing that trial counsel could give us for an explanation as to how it went. The reason I bring this up is part of my brief, and maybe I did not emphasize it as much.
I thought Judge Spurlock consistently gives the model instructions in this case, right?
Yes.
We're pretty comfortable that he's just tracking.
That's true, and the Commonwealth very nicely gave us that copy of that. But what I'm saying is, in taking a look at the McDermott case, what I'm saying is, if we take a look at either the model jury instructions, which are actually cited for us, the 1999 ones, they're cited for us in the Commonwealth's brief at page 42. And if we take a look at, and I call the court's attention to specifically Record Appendix page 317, in which the Commonwealth had asked for what they wanted for murder instructions, and what they basically did, hopefully you will see, is that from both the model jury instructions and what was requested by the Commonwealth as far as their instructions, which got the check mark on it, they get a check mark, and as opposed to but no check marks for what the defendant requested at Record Appendix 299 and 300, and those were articles, paragraphs 53 through 56. All of those instructions talk about mental impairment and intoxication, okay, as it comes to deliberate premeditation. There are none that talk about it with extreme atrocity. And the point that I'm trying to make, Your Honor, is that in fact, there are other cases. I did not cite them because they came up after the fact, but I give them to the court for your own edification. I could make the argument, but I think it's much stronger if at least someone from the SJC made the argument. But the Commonwealth versus Rutkowski, it's 459 Mass 794, 2011 case, and Gonzalez, 469 Mass 410, it's the 2014 case. They mostly said in positions where the instruction specifically talks about both mental impairment and intoxication as it comes to deliberate premeditation, and doesn't mention that at all when it comes to extreme atrocity, a jury could very well find that they're being instructed that intoxication and mental impairment have nothing to do with the extreme atrocity. And what the point is that when either you talk about deliberate premeditation, which is always intent and knowledge, or what's brought into question as far as the defendant's state of mind. In this case, he was not convicted of deliberate premeditation. It was extreme atrocity. And as I believe as the Gonzalez case actually says, extreme atrocity talks about conduct. And those cases that were cited in my brief that were all kind of summarized in the McDermott case, starting with Gould, Perry, Breeze, and Doucette, which are all in the brief, they all talk about the basically the culmination of intoxication and mental impairment as pertaining to extreme atrocity or cruelty. And the argument that make is, again, we don't know. We still, I can't tell you what was actually said, but if I take that as, I'm sorry, I didn't need to interrupt you.
No, I interrupted you, I'm sorry. Assume you're right, and that it didn't get included as it relates to extreme atrocity or cruelty, and talk about the implications of that, because it should.
Yes.
But the Canine factors really have arguably one, but very few subjective components of them. So where's the impact?
The impact, Your Honor, comes, well, again, first off, as far as any prejudicial effect, I would say, of course, because there was no, the guilt was, the murder guilt was on extreme atrocity and cruelty.
This was preserved, right? There was a request to do both and explain the
Yes, Your Honor.
synergistic effect of the two
Yes, Your
together?
Honor. Everything in this case was preserved. They were all requests or motions. Everything was denied. Everything was objected to immediately. Even I objected to my thing with Judge.
So the issue is the prejudice on extreme atrocity with 33 stab.
Right. Right.
And also limited evidence of alcohol here, right? I mean, this is a case where the defendant is apprehended immediately, right?
Well, actually, I don't believe so. I believe the murder or the killing, I'm trying to say voluntary manslaughter, but the killing happened sometime around between 7 and 8 p.m. He was not actually apprehended until close to midnight as he was walking down the street to his karate studio with the machete in it.
But there's also evidence that he spoke to some other people between then, right? And none of them remarked that he appeared to be very drunk.
Well, Your Honor, the stepfather did mention the smell of alcohol.
Right.
Okay, and he did mention alcohol to, again, this is his own self-serving statement, but he did mention that. And I would just, again, call the court's attention, if I can find the thing. I believe it's the Doucette case basically says when, the two things as far as the instruction for extreme atrocity and cruelty, and it related is one, you no longer need to have extreme intoxication. Possible intoxication is what it says.
No, I understand that. My point's a little different, and maybe I'm misreading the law, but we have 33 machete wounds, right? Yep. And we have, you're saying, well, they should be taking into account the alcohol in terms of the extreme atrocity, but he's not extremely drunk. So he's able to, he seems completely lucid and answering questions. So does that figure into the fact that we have limited evidence of alcohol here?
I would agree with you, of course, that there is limited. I'm not going to stand here and say no. But again, there was still a 4 to 5 hour window between when that happened and when this happened. How much the alcohol, and again, there also is evidence as to the mental impairment that he had, as Dr. Ebert had stated, and how much the intertwining of the alcohol and the mental impairment, one playing off the other one. Because I'm not a doctor, I wouldn't know, but I would suggest that we're not just dealing with intoxication only. We're dealing with both the intoxication and the mental impairment. And as I said, because this is a case which and I'm sorry, Justice Lowy, I believe you asked me, and I did have it written down here, that as far as the canine factor goes, there are cases, and if you need it in a 16L brief, sorry, I get nervous, that I could provide that to the court. But essentially, there was the general instruction that you can take all evidence in determining whether someone is acted with extreme atrocity is not, you need to be able to tell them that it's the alcohol and the mental impairment that has the effect on the extreme. It's almost like a combination of all. You can't just say, and because of everything else, you can take anything you want into a fact of that. You'd have to explicitly say you can take mental impairment and intoxication, if you find that, as a factor to find out extreme atrocity and cruelty.
But your point is that the error was that the judge didn't really explain you should take into effect the interaction and the sort of synergistic effect of the two.
Right, Your Honor. It's like and because that's as the cases say that extreme atrocity or cruelty is conduct, not intent and knowledge. If the court has no further questions, I would rest on my brief.
Thank
you for your time, Your Honors.
Okay, Attorney Martino.
Good morning, Your Honors. May it please the Court. Elizabeth Martino on behalf of the Commonwealth. The Commonwealth is asking that the Court affirm the defendant's conviction for first-degree murder. And I would start with the reconstruction issue, if I may, just quickly, because I think it's sort of threshold and then dovetails well with the substantive issues that the defendant raises. I want to just quickly point out that in footnote 17 of my brief at page 52, I argue that the court reporter and clerk's office are not a party in terms of figuring out fault, and that's probably wrong. There was a case out of this court, Compiti versus Commonwealth, 417 Mass 454, where the court said delay in a transcript can be attributable to the Commonwealth. So I just wanted to note that I realize that can be, but as defense counsel has said, fault isn't really the issue here because the fault is sort of spread around among the parties in the delay of the transcript, and there was a reconstruction effort by both parties, as is required by Harris. And there was a stipulation that resulted, which both parties agreed to. So, fault isn't really an issue, I think.
That part of the stipulation didn't address whether or not what the defendant told Dr. Ebert was admitted only to, as a basis for the opinion and not for its truth, right?
I believe that's correct, and that is something that I just thought of as defense counsel was arguing. I believe that's correct. I don't know that whether or not a limiting instruction was given is addressed.
That means our universe of facts for sudden combat is the defendant's statement to Sergeant Keeler and the defendant's statements to Dr. Ebert, right? Is there anything else?
No, there's nothing else. I just, I don't know whether in the absence of an agreement in the stipulation about whether there was a limiting instruction or not, that we presume that there was no limiting instruction, and that the statements came in substantively when the rule of evidence really is that these statements made to a doctor only come in, for the purposes of
But just in case, why don't you argue why, looking at the statements to both, your position that it's not sudden combat?
Yes, so assuming that there was no limiting instruction, there's still no sudden combat instruction required here, because the sudden combat cases are where there is a sudden attack by the victim on the defendant, such that the defendant is in a heat of passion and cannot sort of control his actions and acts out of that heat of passion.
If this isn't raised in your brief, so, and I may be wrong about this, but the fact that the jury was instructed on reasonable provocation, heat of passion, and they found beyond a reasonable doubt that it didn't exist, does that talk anything about reasonable provocation in this instance, where there was no strike to the defendant?
I believe that it does, Your Honor. I think first, so based on the verdict, we can surmise that the jury did find that the defendant was not acting out of heat of passion that eclipsed his self-control, right? Because they were instructed on the heat of passion, reasonable provocation by heat of passion, and they did not find voluntary manslaughter. Reasonable provocation by sudden combat also requires that eclipsing of self-control, which the jury did not find. In addition to that, I believe that there was no sudden combat because there was no physical attack by the victim on the defendant.
How do we, that's the part that it gets tricky for me. Because, again, and you and Justice Lowy know these cases better than I do, but, so somebody's, let me change the facts a little bit. We've got two guys, carrying machetes, and they start yelling at each other, and the victim swings first, and he comes right in front of him. He takes this big knife and almost cuts off his nose. And the other guy swings back and cuts off his head. No sudden combat there?
No, Your Honor, and there's three different,
Wow.
Well, that factual scenario, I think, is a self-defense case or voluntary manslaughter by excessive self-defense. And there are, factual scenarios that...
Forget about self-defense. I'm just trying to understand. If I'm the victim, I'm carrying my machete, and I initiate the swinging of that machete, and I just barely miss. And the guy who's carrying his own machete says, cuts off his head. Yeah, really? No sudden combat there? You gotta, our cases say you actually need to make contact.
They do, Your Honor, and they contemplate, a physical fight,
Well,
as opposed to...
I'm talking about a physical, in my scenario, because I'm just trying to understand, my scenario may not apply here, but just because it's a man and a woman doesn't mean we don't have two drawn machetes at each other, in a domestic dispute. So I'm just trying to get a sense. But again, under my hypothetical, still no sudden combat instruction.
No, Your Honor, and I would point out that there is still an avenue for a defendant to argue for a voluntary manslaughter conviction as opposed to a murder conviction under your factual scenario.
It might even be, first of all, excessive force self-defense, but Justice Kafka's description might be reasonable provocation, heat of passion when you have that machete coming close to you. But do we have a case in Massachusetts? Has the SJC ever in a case said where the defendant wasn't touched at all, that there's sudden combat?
I didn't find one, Your Honor. And also, if you look at the model jury instructions, they say that sudden, and I'm reading from the instruction, sudden combat involves a sudden assault by the person killed and the defendant upon each other. In sudden combat, physical contact, even a single blow, may amount to reasonable provocation. Whether the contact is sufficient will depend on whether a reasonable person, and blah, 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 blah. So the whole thing is about contact, fighting,
Well, the word
physical.
assault is the opposite, right? Assault is without contact. That's why we have assault and battery, right?
Yes, but it says a sudden assault in sudden combat, physical contact, and whether the contact is sufficient. So I think, there are, under your factual scenario, certainly the defendant can still argue for a voluntary manslaughter conviction. It's just not a voluntary manslaughter conviction by sudden combat. So it's by excessive force, possibly by heat of passion. Certainly they can argue for an acquittal by self-defense, but
I guess I always find it odd that the provocation one, again, we have your honor is questioned, so we've been allowing these, these silly defenses. You think your significant other is having an affair, so you're so provocated that but at the same time, the physical contact is required. So it just seems it's easier to get the provocation in these old-fashioned cases than it is the sudden combat part of it, right?
Well, yeah, and I would note that the heat of passion, I think has been applied to cases where there's been like a history of anger between the parties, and not just domestic situations, but...
And again, it doesn't matter that, again, we have evidence here that she struck him with a machete previously.
There's a statement to the doctor, she had hit me before, I think, but not, again, there was nothing in his statement to Sergeant Detective Keeler about that.
That statement indicate she'd hit him with the machete before? Or just that she'd hit him before?
No,
It was in the context of talking about her machete, so I think it can be construed that way. But I would note also that the statements about the victim's conduct here don't get nearly as close to, like, she swung very close to me and it just missed and it almost hit. Do you know what I mean? It was not.
I figure out in the light most favorable to the defendant, because, again, she's murdered down the stairs. She's in bed when this starts. I just can't, I'm trying to do the light most favorable to the defendant and see whether there's a break in the action. I just can't decide that yet. I haven't read the whole transcript.
Yes, yes, and that is a good point, Your Honor, too, that there isn't anything here that I think would show that the defendant had been provoked to act out of emotion rather than reasoned reflection, especially where, you know, the conflict starts where the victim is lying on the bed, kind of with her eyes closed, and the defendant starts badgering her about where have you been, what have you done, where have you been, and then they start fighting. You know, she, according to the defendant, pulls out the machete and swings it, and then they run down the stairs, and it is down the stairs where the defendant attacks and stabs her 33 times. So there's a break sort of in the action. There. And again, the jury did not find, because they were instructed on reasonable provocation by heat of passion, which requires that same acting out of, you know, eclipsing self-control, and the jury did not find that because they convicted him of first-degree murder. So I think we are sort of bound by that here in terms of a prejudice argument. Sorry, are there any other questions on sudden combat? No. And then I think moving to...
This is McDermott argument, because that gets I mean, I have a lot of trouble translating this to extreme atrocity and cruelty, but we have apparently done it, right? Right.
So I don't think that I addressed in my brief as completely as I could have. I thought the claim was more about the intersection of the mental impairment and the intoxication, and that was the error being claimed. In terms of that, it wasn't explicitly, the mental impairment instruction wasn't explicitly about the extreme atrocity. I would argue that the intent required for first-degree murder by extreme atrocity is not a specific intent. It's the, you know, three prongs of malice, and then it's the conduct, the extreme atrocity, whether it was also, you know, an extremely atrocious murder, but there's not a specific intent as to the extreme atrocity. So here, where there was...
Have to be, though. It's more complicated than that, because you could have no premeditation, but you could have an intent to kill and not have a murder one on premeditation, but you could consider the intent to kill as one of the three ways of having intent on extreme atrocity or cruelty. It doesn't have to be the other two intents other than intent to kill.
Right.
So it's theoretically possible that there is an intent in a extreme atrocity or cruelty being considered.
Yes, and I think that was addressed by the judge's instruction, which is in the stipulation at the defendant's appendix, page 317, where the judge instructed, and this is a quote, "In determining whether the Commonwealth has proven beyond a reasonable doubt that the defendant acted with deliberate premeditation and that he specifically intended to kill Lisa McLester, you should consider all the credible evidence relevant to deliberate premeditation and intent to kill, including any credible evidence of the defendant's alleged mental impairment."
But isn't that the instruction that was found deficient in McDermott?
That I don't know the answer to.
Because you have to let the jury know any time that there's an intent, and grievous bodily harm has to be an intent. Even plain and strong likelihood of death has an intent component. So it was error. If it wasn't given on extreme atrocity or cruelty, that was error. It's what's the prejudice from it?
Right. Well, right. Okay. So yes. So then, I again, as the court was asking the defense counsel, I think that prejudice is just not apparent on this record, right? Because there was 33 stab wounds by the defendant. The evidence of intoxication was slight here, if any, and Yeah, I think that, those are really the facts that support that there was no, prejudice, here. Yeah. I don't know if the court has any other questions on that. I think that is really the argument here, and that the stipulation, as it was agreed to by defense counsel and by the prosecutor, did specifically say that the judge gave all the model jury instructions as to, each of the instruction that was agreed, that was given, including the intoxication and the mental impairment.
But again, the McDermott instruction is not a model instruction, right? It's a supplementary kind of instruction.
Yeah, so then the question is, the prejudice. But here, I think, given the facts of the case, there's just none on this record, and that the conviction for first-degree murder is proper. I don't know if the court has any other questions, and if not, the Commonwealth rests on its brief. Thank you.